enacted. The latest filing in litigation against Illinois' gun and magazine ban up in the Seventh Circuit Court of Appeals comes from Thomas Magg. Now, background on Thomas Magg, he is the attorney who first filed a lawsuit against Illinois' gun and magazine ban enacted June 10th. He filed it in state court in Crawford County, and that ultimately was transferred from state court to federal courts in the Southern District of Illinois, where you then had his case with three other cases combined. And they were heard in April, and the judge, Stephen McGlynn, for the Southern District Federal Court, issued a preliminary injunction on the case, essentially halting the law from being enforced. But the states went directly to the Seventh Circuit Court of Appeals, requested a stay, and that case was ultimately the decision for a preliminary injunction was reversed after only 6 days. So that case, of course, is now up in the Seventh Circuit, combined with Northern District federal court cases where judges sided with local and state gun and magazine bans. And those cases all consolidated in the Seventh Circuit. You had briefs filed by the state and by local governments. Essentially, I'm going to distill this down the best I can. Their arguments were that firearms now, semi-automatic firearms, are much more technically advanced than what our founding fathers would have thought. That's one of the arguments they have, and it makes them more lethal, they argue. They also say that semi-automatic firearms that are banned are not used for lawful purposes. And they're dangerous and unusual, and also that the recent spat of violent crime, including mass shootings, they say that requires the states and local governments to do something. So those are some of the arguments, but when we look at the plaintiffs' briefs, they slap that down, essentially looking at the Bruen decision from the U.S. Supreme Court, the New York State Rifle and Pistol Association versus Bruen, a case that was decided by the U.S. Supreme Court last year that ultimately Second Amendment rights supporters say really changes the game when it comes to how courts should evaluate gun legislation and laws in various states. So looking at the Seventh Circuit Court of Appeals, in their docket, you've got the latest that has been ultimately filed here, and throughout this week, we've seen the filing coming from the Barnett case, but also you've got the Langley case, and that's the case that Thomas Magg has. And earlier this week, we didn't have the case yet; it was filed, but had to be approved, and it was approved. So now we have that case overview, and we'll just go through some of this. Again, Thomas Magg filing this on behalf of his client, Langley, and various other appellees. And this is in the Seventh Circuit and goes through what cases they're going to be talking about. It talks about whether a citizen convicted of no crime, suffering of no mental illness, addicted to no narcotic or illegal drug, and who are simply ordinary Americans can be deprived of access to common modern firearms and ammunition feeding devices for said firearms simply because the state, in this case, Illinois, says so. It goes on, about a year ago, the Supreme Court issued an opinion in the New York State Rifle and Pistol Association versus Bruen and held the Second Amendment protects the possession and use of weapons that are in common use. And I think that in common use theme has been pretty prevalent in all of the plaintiffs who have filed these cases. Just a few months later, in January, the state of Illinois enacted with great fanfare the Illinois Public Act 102-1116, which by any other name is simply a firearm and magazine ban for firearms largely of mid to late 20th century design and or manufacturing. Penalties for violating this law range from minor misdemeanors to major felonies, depending on the particulars. Of course, a felony conviction and several other statutes bars possession of firearms and ammunition, meaning a violation of the statute has the potential to deprive plaintiffs of all of their Second Amendment rights. Now, this filing from Magg, it's only 27 pages long, so it's a pretty easy read if you have access to these arguments and these filings. So it goes on to talk about the statements of the issue, and it talks about the case and when the Protect Illinois Communities Act, or the ban on semi-automatic weapons and magazines, that was enacted January 10th. Firearms are not new in invention or some radically advanced departure from what came before them, or from what has been on the market for over 100 years. He then points to some of his documents. They're quite simply modern incarnations or incantations of the lineal descendants of Brown Bess and Charleville, muskets of the Revolutionary War era. Consistent with the purpose of the act to ban any modern firearms as possible, the act defines the prohibited firearms mostly, but not exclusively, semi-automatic in terms of the features that individually or in combination render the ideal for citizen self-defense. After all, core while hunting may be a legitimate lawful activity under the Second Amendment. The core purpose is of armed confrontation, not deer hunting. Again, Thomas Magg not really holding any punches here. In fact, these firearms are the modern lineal descendants of the Brown Bess and Charleville military arm used in the Revolution that evolved out of the Henry Winchester rifle and so on. He gives more background on that. And listen, I've talked to Magg several times, and you've heard his conversations with me on the air here. Magg's very, very knowledgeable about firearms, all of the ins and outs and the history of these firearms. Magg was also the attorney down in the Southern District when the case was heard, when the state would put up a exhibit and it showed what they said was a grenade launcher. Magg was quick in court to say that's not a grenade launcher, that is a flare launcher. And even saying that, this brand, it's not even the right dimensions. It's not even the right caliber for launching a grenade. So I think the judge in the Southern District took that to heart. But goes on just to talk more about the case and their arguments. And again, I think that as we see these arguments being filed, you have the case that's going to be heard in the Seventh Circuit Court of Appeals on June 29th. So we're a week away from that. Up in Chicago, it'll be heard. But Magg also, if you recall, he filed in the Southern District last month a motion for summary judgment partial on vagueness. So Magg actually went back from the Seventh Circuit back to the Southern District to ask Steve McGlynn, the judge down there who handled the case. He's asking for partial judgment, saying that the law is too vague. And the latest docket entry on that does not show that the state has replied. So still a lot of moving pieces when it comes to litigation against Illinois' gun and magazine ban. So a week from now, it'll be heard. But before that, we've got reply briefs that will be filed. So it's going to be a pretty big week ahead in the litigation against Illinois' gun and magazine ban. I'm Greg Bishop. Thanks for hanging out each and every weekday morning. You can find me anywhere. Just search Bishop On Air. Again, Bishop On Air, Twitter, Facebook, YouTube, Instagram, wherever. Just search Bishop On Air and we can connect that way.